The Rules Committee will come to order. I want to say a few things before we get to the agenda for today's meeting. This committee is like a family, and sometimes to the outside world, we appear to be like a little bit of a dysfunctional family, like the Addams family, right? But we are a family nonetheless. And today, our family is in mourning. We are grieving the loss of our distinguished vice chair and our dear friend, Congressman Elsie Hastings. I've sat beside him on this committee for a very long time, and there wasn't a day, not one day, where he didn't bring a sense of joy and purpose to our work here. That was true whether he was in the majority or in the minority, and whether he liked the bill that we were considering or whether he didn't like a bill we were considering. Though, to be clear, you never wanted to be on the other side of an argument with Elsie Hastings. And, I always remember that after his very passionate presentations, he would usually conclude by saying that that's my story and I'm sticking to it. And if I offended anybody by anything I said, it was intentional. Um, he brought such tenacity to everything he did, whether he was fighting for those who needed a voice or fighting his courageous battle with cancer. And I think I speak for all of us when I say that we will miss his wisdom, his decency, his compassion, and his humor. There was no one else like him. And our prayers are with his family, with his constituents, and with his staff. Let me turn now to our ranking member for any remarks that he wishes to share.
Thank you very much, Mr. Chairman. And first of all, I certainly want to associate myself with your remarks. We all have Elsie Hastings stories, and I had the privilege of serving with him every day that I've been in Congress and on this committee for almost 10 years. While I have a lot of respect for everybody on this committee, most of the people that are here over the years are here partly because they are not only passionate in what they believe, they're awfully good at expressing what they believe. I don't think anybody matched Elsie Hastings in terms of sheer eloquence when he was on a roll. And he's certainly the only member of this committee I ever dreaded going into a debate with because you were going to get verbally drubbed pretty good, and you knew that he was going to make his points not only with passion, but with precision and clarity. He really was a superb debater, as we all know. But more than that, he was just a superb human being. He was a wonderful colleague. I admired him every day that I served with him, but probably never more than I watched him carry on as he was in this heroic struggle with cancer. And to see him show up day after day when he could on the floor in situations where I know I would not have been here, and I suspect most of us would not have been here, was just a remarkable testament to his courage and to his commitment to this institution. As you pointed out, Mr. Chairman, he was here long enough to serve in both the minority and the majority, and so he knew what it was like to be on the upside of this and to walk through the valleys that we all go through. But he never lost his sense of humor. And he never failed to come over and congratulate you after he was done, beating you into the ground verbally when you were on the floor. And his wit and his sense of knowing when to speak and honestly when not to, of knowing what points would be effective, were just remarkable. I knew a lot about him. Before I got here, I actually was the executive director of the NRCC when he was elected in 1992. And I remember telling him later, I said, well, just remember, we didn't spend any money against you. And he immediately quit back. That's because you couldn't beat me, which was, of course, true. He was, quite remarkable in his political skills. That's what I was astonished when I was reading one of his obituaries. He'd actually lost 8 elections to various offices before he won in Congress. And that just tells you something about the sheer drive that he had, that he was willing to put himself in the arena again and again to make the points that he thought were important. And while he was passionate domestically, I think we all know he was one of the most knowledgeable people we had on the international scene as well. Wonderful person to travel with, wonderful person to talk about America's role in the world with, and somebody that always had an insightful point to make. So I'll miss him. I'll miss, as you pointed out, his decency, his good humor, his civility, his sheer talent in expressing the things that he believed and representing the causes with which he was associated with such great vigor and such great dignity and such great effectiveness. Um, there's a number of people I think of when I think of, boy, that's a model member of Congress. And Alcee Hastings was one of those people. They don't have to be on your side for you to admire them and admire the manner in which they conduct themselves. Again, so speaking for our side, I know he was very beloved. I know it'll come a shock to you. Not all of you are, as I suspect is true when you think about our side. But Alcee Hastings was liked by both sides of this institution, and it was admired by both sides of this institution. So I share your grief for his family and for his many, many friends of both sides of the aisle. And I share your admiration, Mr. Chairman, for his commitment of service to this institution, to the people that he represented, but more deeply to the people all across the country. I think of him as a national congressman with a national following and national points to make. And while he represented his area very, very well, he was never parochial. He found ways to address causes that were greater than his district and causes that were worthy for all of us to be focused on. So I'm going to miss him. I'm going to miss his humor and his decency and his fellowship, and just the sheer pleasure of serving each and every day with him, either in this committee or on the floor of the Congress of the United States, where he acquitted himself in a manner that could make all of us proud, serving in the same institution with him, and make all of his constituents proud of the kind of person and the kind of voice that he represented for them in the deliberations of Congress. So I share your grief and again, associate myself with your remarks. We'll all miss Alcee Hastings.
I thank the gentleman for his remarks, and as I said, our prayers are with his family and his constituents and his incredible staff. And I would like, if we could at this moment, just pause for a moment of silence in honor of our colleague and friend, Congressman Hastings. All right, thank you. And now let me turn to our agenda for today. We're taking up two bills. The first is HR 7. It has been nearly 60 years since Congress took action to ensure equal pay for equal work. But today, women continue to make only 82 cents for every dollar earned by men. That gap is even more prominent for women of color. This is true across virtually every occupation in every state across the country, and it harms entire families and our economy. Every Democrat in the House has co-sponsored the Paycheck Fairness Act, and I'm optimistic that my Republican friends will join us and support the bill on the floor. And hopefully it will finally be taken up in the Senate and then signed by the President of the United States. It is time to make equal pay for equal work a reality in America. Second, we are taking up HR 1195. Our healthcare workers put their lives on the line for us every single day. We've all seen their selflessness again and again during this pandemic. Yet many have little to no training on how to prevent or handle interactions that become violent. In fact, many have come to view acts of violence as just part of their jobs. Well, it shouldn't be. It is time that we make this bill a reality and give our healthcare heroes the added protections that they need. I hope that their work during this pandemic will inspire my colleagues on both sides of the aisle to support this bill. The best way to thank our healthcare workers is to give them the protections that they deserve. Now, let me turn again to our ranking member, Mr. Cole, for any remarks he wishes to make.
Thank you very much, Mr. Chairman. Before I address the bills, let me just thank you for opening our hearing in such an appropriate way in memory of our dear departed colleague, Mr. Hastings. Today's hearing covers two bills coming out of the Education and Labor Committee. The first bill I'll address is H.R. 7, is known as the the Paycheck Fairness Act. Unfortunately, this bill is a very blunt instrument being used to address a complex issue. It's a bill written by trial lawyers for the benefit of trial lawyers and will ultimately end up causing much bigger problems for employers and employees alike. The Paycheck Fairness Act is intended to address the gender pay gap, which reveals that on average, women receive lower pay than men. But the causes of this problem are deeply complex and results from a wide variety of factors not addressed by today's legislation, including decisions made by individuals about educational paths, career choices, and whether to leave the workforce to raise children. Attributing the entirety of this complex problem to workplace discrimination is simply not warranted. If the majority's goal is to ensure that it is illegal for an employer to pay employees differing salaries based on gender, then they're in luck. That's already the law of the land. Since the passage of the Equal Pay Act in 1963, gender-based wage discrimination has been illegal in the United States, as it should be. But today's bill goes much further than the Equal Pay Act, and it does so in a way that will only benefit one specific class of people, trial lawyers, at the expense of working women. The Paycheck Fairness Act makes changes to the Fair Labor Standards Act to make it harder for employers to present a bona fide factor defense to a claim of wage discrimination. It substantially increases the monetary damages that are available for such claims, including penalty mechanisms and punitive damages. With these increased damages and reduced ability to offer a defense, employers could be subjected to nearly unlimited damages, even for inadvertent or unintentional pay disparities. And since lawyers who bring lawsuits under the Equal Pay Act are allowed to recover a reasonable attorney's fee, which can be a percentage of the recovery, the enhanced damages provide strong incentive for lawyers to bring such claims, whether they are warranted or not. This is a recipe for a massive increase in litigation without corresponding benefits for working women. The Paycheck Fairness Act may be well intentioned, but it is ultimately an overly simplistic solution to a complicated issue, and it will ultimately cause more harm than good. I strongly urge the majority to rethink this course. The second item I'll address is H.R. 1195, the Workplace Violence Prevention for Healthcare Social Services Workers Act. The bill is intended to address workplace violence for healthcare workers and social service workers and to ensure that OSHA issues an appropriate regulation to address the problem, which is, as the chairman said, a very real problem. As the hearing in the Education and Labor Committee demonstrated, there's still clear disagreements about this bill, and in particular, Republicans on that committee have expressed concerns that this bill is overly prescriptive and will force a truncated regulatory process that may not be appropriate. While I'm supportive of this bill, quite frankly, I would also be supportive of the Republican alternative as proposed during the markup. I look forward to hearing from my colleagues both about this bill and the proposed Republican alternative during the hearing today. But let me reiterate, I agree with the chairman. This is a very real problem, and I'm pleased that both sides, frankly, have ideas about how to address it. Hopefully, we can work through that and end up with a good solution. With that, Mr. Chairman, I yield back.
All right, thank you very much. The gentleman yields back. I'd like to welcome our witnesses to provide testimony on H.R. 7, the Paycheck Fairness Act, and H.R. 1195, the Workplace Violence Prevention for Healthcare and Social Service Workers Act. Chairman Scott, Ranking Member Fox, Representative DeLauro, Representative Courtney, we are delighted that you are here. Without objection, any written materials you submit to rules.documents@mail.house.gov before the conclusion of this hearing will be entered into the record. I now recognize the gentleman from Virginia, Chairman Scott.
Thank you, Mr. Chairman. Ranking Member Cole, I'm pleased to speak to you today on H.R. 7, the Paycheck Fairness Act, which passed the House last Congress and enjoys bipartisan support. It is inexcusable that in 2021, women still earn, as we've heard, on average, 82 cents for every dollar earned by their male colleagues. This gap is far worse for women of color who make less than both white men and white women. And it persists today in nearly every line of work, regardless of education, experience, or occupation. Need for Congress to secure basic fairness for women in the workplace has become even more urgent today. COVID-19 pandemic drove over 2 million women out of the workforce during the past year. This steep drop in women's labor force participation risks further exacerbation of the gender pay gap when these women re-enter the workforce. Paycheck Fairness Act, championed by the gentlelady from Colorado, Ms. DeLauro. She's been fighting for that for decades to make significant strides to close the persistent gender gap, which would, by strengthening the Equal Pay Act. This bill bolsters workers' rights to discuss their wages. It makes it easier for workers to join class actions. It enhances the tools for the Equal Employment Opportunity Commission and the Labor Department to have improved enforcement of the Equal Pay Act. Most important, it requires employers to prove that pay disparities exist for legitimate job-related reasons. It's been 58 years since President Kennedy signed the Equal Pay Act, but the gender pay gap continues to erode the financial security of women and their families. This bill will help fulfill the promise of equal pay for equal work. Mr. Chairman, I want to again congratulate the gentlelady from Colorado for her long support of this legislation, and I yield back the balance of my time.
Yeah, so did the gentlelady move from Connecticut to Colorado? I think she's, yeah.
She would like to move to Colorado.
Did I say Colorado? Excuse me, I meant Connecticut if I said
I
Colorado.
said, that's okay, Congressman Scott. I said, but I am from Connecticut.
Whatever, Connecticut. I'm sorry.
That's okay. No problem.
And thank you for allowing me to correct myself. Thank you.
Okay.
Gentlelady from Connecticut.
I now yield to the gentlelady, the ranking member, Virginia Fox.
Thank you, Mr. Chairman, and thank you, Ranking Member Cole, for the opportunity to speak today. I also want to make one quick comment about Alcee Hastings. I had the opportunity to serve with him on the Rules Committee also, and Alcee and I were good friends. And I appreciated something that Ranking Member Cole said, that he was not a parochial person. He did see things in a broader light. And he also understood the importance of education and supported all types of education, contrary to many of his colleagues who did not support certain sectors of post-secondary education. And I particularly appreciated his willingness to buck the majority on that issue. And he was very sincere in it and worked hard, again, to allow people to have choices when it came to post-secondary education in particular. So I'm going to miss him also. Again, Mr. Chairman, thank you for the opportunity to speak in opposition to H.R. 7, the Paycheck Fairness Act, and H.R. 1195, the Workplace Violence Prevention for Healthcare and Social Services Workers Act. These two Democrat proposed bills claim to protect the rights and safety of workers, but both fall woefully short. The purpose of both bills is commendable, but they do nothing to support the very workers Democrats claim to aid and will lead to harmful, unworkable policy. Instead, these bills are a partisan ploy to pander to trial lawyers and union bosses at the expense of hardworking men and women. I want to associate myself with Ranking Member Cole's opening remarks. They're absolutely excellent, and I endorse them. As he said, this is a bill written by trial lawyers for trial lawyers. Regarding H.R. 7, equal pay for equal work has been the law of the land in this country since 1963, when the Equal Pay Act amended the Fair Labor Standards Act. A year later, Title VII of the Civil Rights Act codified non-discrimination based on race, color, national origin, religion, or sex. These laws have protected workers' right to fair pay for decades. H.R. 7 will drag women through frivolous lawsuits while plaintiffs' lawyers get handsome financial payoffs and business owners are left to fend for themselves. While the bill does nothing for working women, the damage to employers and the economy will be irreparable. H.R. 7 requires business owners to convince a judge or jury that 100% of a pay difference between employees of the opposite sex was required by, quote, business necessity, end quote. Requiring that an employer demonstrate the entire pay differential is due to, quote, business necessity, end quote, is unworkable and ludicrous. The economic impact of the bill's government data collection mandate will be devastating. H.R. 7 directs the EEOC to collect pay data disaggregated by the race, sex, and national origin of employees, including hiring, termination, and promotion data. It raises serious privacy concerns, and this added burden will result in an estimated annual cost to employers of over $600 million. Democrats will tell you this bill is necessary because of the wage gap, but this claim is unfounded. Upon careful examination, most of the wage gap completely disappears when factors such as hours worked per week, rate of leaving the labor force, and industry and occupation are considered. My colleague, Representative Stefanik, offered a substitute amendment to H.R. 7 at the committee markup that included robust protections for workers while still ensuring due process for employers. But Democrats unanimously voted against this common sense proposal. Representative Stefanik has submitted the same amendment to this committee, and I asked the committee to make it in order under the rule. Moving on to H.R. 1195, the Workplace Violence Prevention for Healthcare and Social Services Workers Act. This is yet another bill that purports to protect workers, but unfortunately is so overly prescriptive and heavy-handed that it will do much more harm than good. Workers in the healthcare and social service industries are at an increased risk of workplace violence, with the Bureau of Labor Statistics finding that they are 5 times more likely to experience violence at work than an employee in any other field. Republicans are committed to ensuring American workers are safe in the workplace. However, this bill is a far cry from a sensible solution. H.R. 1195 purports to take workplace violence seriously, but this legislation will result in a rushed, rigid rule that fails to consider meaningful input from the public or any stakeholders within these industries as required under the standard OSHA rulemaking process. Furthermore, the bill would impose yet another careless regulation on businesses which have been heroically fighting on the front lines to battle the COVID-19 pandemic. Democrats have created a false sense of urgency, claiming that the OSHA rulemaking process takes too long, which is why they need to ram through this unworkable bill. Yet OSHA has been inspecting job sites for complaints related to workplace violence and issuing citations, when appropriate, since the Obama administration. Additionally, OSHA is already in the process of writing a workplace violence regulation, and nothing is preventing the Biden administration from finishing this important work. If H.R. 1195 passes, it will force OSHA to abandon its normal rulemaking process, which allows for valuable input from the public and interested parties who have crucial insight, expertise, and experience to offer. The OSHA rulemaking process also includes important regulatory evaluations. such as a cost-benefit analysis, to ensure a sensible, evidence-based rule. OSHA has also announced plans to convene a Small Business Regulatory Enforcement Fairness Act, SBREFA, panel to gather valuable feedback from small businesses before a regulation is written. HR 1195 would sidestep these efforts, resulting in a rushed interim final standard that may be infeasible for small businesses. In addition, the Biden administration is soon expected to issue sweeping and burdensome OSHA regulations on COVID-19 and a permanent infectious disease standard, which will significantly impact the healthcare industry and create unanticipated consequences related to writing a workplace violence regulation. HR 1195, which forces OSHA to issue an interim final standard within 365 days, is ill-timed, and the lack of necessary feedback and insight will render the standard ineffective and overly burdensome. On this bill as well, Representatives Keller and Wahlberg have filed an amendment that presents a workable solution. The amendment allows OSHA to complete the much-needed analysis and would ensure that the regulated community has an opportunity to provide meaningful comments on a workplace violence prevention standard. The amendment would require OSHA to conduct an educational campaign on workplace violence prevention in healthcare and social services industries. This common sense amendment acknowledges and supports the work already underway and protects this progress so it can further propel solutions to workplace violence. I ask that the committee make this amendment in order under the rule. Mr. Chairman, in conclusion, HR 7 and HR 1195 will actively harm those it purports to help. As I said at the start, good intentions do not always lead to good policy making. That is unfortunately the case with both bills we're discussing today, and I yield back.
Thank you very much. I'm now happy to yield to the distinguished chairwoman of the Appropriations Committee from the state of Connecticut, Ms. DeLauro.
Thank you so much. And I want to say a thank you to you, Chairman McGovern, Ranking Member Cole, for this opportunity to testify about the Paycheck Fairness Act. Let me also recognize Chairman Bobby Scott and the members of the House Education and Labor Committee who have helped us come so far. This moment represents a significant milestone for women in the workplace, and I think we all should be very, very proud. I also want to acknowledge my colleague, Congressman Courtney, and his work on worker protections in HR 1195. With regard to the Paycheck Fairness Act, for more than 2 decades, we have pushed and battled to strengthen the Equal Pay Act of 1963. We launched side by side into the fray to elevate pay discrimination, to emphasize how central it is and its impact is to working families. I cannot tell you how difficult it has been to break through on something so simple. Men and women in the same job deserve the same pay. My God, it is a principle that we adhere to in the Congress. Should we upend that? Does it make any difference what part of the country you come from? What your skills are? What your interests are? It is just, we all, wherever we come from, Colorado, Connecticut, Oklahoma, Virginia, wherever we come from, we make the same amount of money, men and women. Why? Because we are in the same job. I also might add that this is also very true for the military, except for those who get addition with combat pay, and women are not in combat. So it's true in the Congress, true in the military. Last month, we recognized Equal Pay Day on March 24th. Is the day into the year that women must work to meet the wages earned by men in the previous year. National Committee on Pay Equity tells us at its lowest point in 1973, full-time working women earned a median of 56.6 cents to every dollar that full-time working men earned. Today, Women who work full-time year-round are paid on average only 82 cents for every dollar paid to men, resulting in a gap of over $10,000 each year. The gap exists in every state, regardless of geography, occupation, education, or work patterns. Worse for women of color. On average, Latinas are typically paid 55 cents and Black women 63 cents. And my own personal view, it is a reflection of the lack of respect for women's contributions to our economy. And now the issue and the environment have collided. This last year has brought unprecedented challenges for our country and the world. It has brought out the depth of our problems and exposed existing inequalities, like women's economic insecurity at a disproportionate rate. But the moment has allowed for transformative change, and equal pay for equal work's time has come. The Paycheck Fairness Act, bipartisan legislation, I might add, which has every member of the Democratic caucus signed on as a co-sponsor, and 3 Republicans, would toughen the remedies in the Equal Pay Act of 1963 to give America's working women the opportunity to fight against wage discrimination and receive the paycheck they have rightfully earned. And well to note that in the past, when this has come up and where we have won on the floor of the House 3 times, it has been bipartisan as well. What does the bill do? It requires employers to prove that pay disparities exist for legitimate job-related reasons, bans retaliation against workers who discuss their wages, removes obstacle in the Equal Pay Act to facilitate a wronged worker's participation in class action lawsuits, improves the Department of Labor's tools for enforcing the Equal Pay Act, provides assistance to all businesses, and creates negotiation skills training program. And it would prohibit employers from seeking the salary history of prospective employees. We have passed the Paycheck Fairness Act in the House 2008, 2009, 2019, but now in the 117th Congress, in which we welcomed the most women in our history, we must get it into law. We have the opportunity to make good on the promise that presidents of both parties have made. Let us seize it. I thank you, and I yield back.
Thank you very much. I now yield to the gentleman from Connecticut, Mr. Courtney. You need to unmute.
Thanks, Jim. Thank you, Mr. Chairman, and thank you, Ranking Member Cole, for holding this hearing today. I want to also just begin by, really complimenting both of you and your remarks regarding Elsie. I think both of you really captured the essence of him. And, as the Irish say, he didn't have airs about him. He was somebody who, was a friend to all, whether he was sitting in that seat that he always sat in on the floor of the House right next to the aisle, so he could socialize with all of us, and he will be greatly missed. So thank you for your great remarks. And I also just want to tip my hat to my neighbor, Rosa DeLauro, who I don't think would ever move to Colorado. She is a Yankee fan, so we don't agree on everything, but certainly I strongly support her legislation today, which is long overdue. The Workplace Violence Prevention for Healthcare and Social Service Workers Act that's before us today is familiar to, I think, a lot of you, because we passed an identical bill on the House floor in the last Congress by a solid bipartisan vote. Since that time, with the onset of COVID, there has been, deservedly so, a massive outpouring of public support for healthcare workers who have risked their lives and health to treat patients during the pandemic. But even as these workers were praised for the work that they did in dangerous conditions, due to the risk of infectious disease, they continue to face another deadly threat to their safety, namely frightening levels of violence at rates that far exceed those faced by workers in other sectors. In fact, the Bureau of Labor Statistics found that 70% of all violent incidents that happen in American workplaces happen to healthcare and social assistance employees. BLS has tallied year in and year out tens of thousands of violent incidents that could be prevented by the standard that's called for in this legislation. The primary source of this violence comes in the form of assaults, kicking, hitting, spitting, even injuries with weapons from patients, residents, and clients, or those who accompany them. HR 1195 would require an enforceable workplace violence prevention standard for this population, within 42 months after enactment. It's not instant, it's 3.5 years, which will give OSHA plenty of time to have a somewhat timely regulatory review and administrative law process. And it would affect 200,000 healthcare centers. It will not affect small doctors' offices or small health clinics. We wrote that into the bill, again, at the request of Republicans, and that was a reasonable one when we drafted the bill in 2019. The standard would require that covered employers develop a workplace violence prevention plan that is tailored to the specific conditions and hazard presented at each workplace. I want to emphasize, so it is not a one-size-fit-all mandate. And that language is on page 10 of the bill if you want to cite it or check for yourself. These plans range from improved patient handoff procedures to improved lighting to personal alarm devices to ensuring that workers treating high-risk patients are not alone. Since 1996, OSHA has published voluntary guidelines that recommend many of these common sense preventive measures that employers can use to reduce the risk and severity of violent incidents. While these OSHA guidelines are an excellent resource, indeed, there are studies that show that hospital systems that deploy them have shown great success. And Congresswoman Scanlon from the Philadelphia area is probably familiar with the area Jefferson Hospital System. They followed these guidelines. And I don't know if you can see, but this is the chart that shows the reduction in cases, which has steadily come down since they implemented it, as well as another chart which shows the reduction in workers' compensation costs, which is good for the hospital system that these guidelines actually produced. So, but however, the fact that we continue to see a growth in violence means that relying on ad hoc voluntary adoption is not doing the job to protect our healthcare heroes. In order to ensure that the OSHA guidelines that have been on the books now for 25 years are adopted and implemented, we need OSHA to issue an enforceable standard. It's important to note that over the last 5 years, in the last 2 administrations, despite some expressions of support for OSHA to adopt an enforceable rule, absolutely nothing has moved in the administrative process and in the rulemaking process. With no deadlines and statutes, OSHA, on average, takes 15 to 20 years to issue a standard. And I have specific examples if members, don't believe me. I mean, it is incredible how long it takes for a rule to get generated at OSHA. Given the fact that OSHA already has guidelines that have been on the books for 25 years that have been vetted and studied repeatedly, including by GAO at the request of Congress, every year we fail to enact this legislation, we are condemning thousands of nurses, doctors, aides, EMTs, and social workers to suffer preventable injuries on the job, sometimes fatal. And we did have a fatal incident out in Minnesota in February where a disgruntled patient showed up at a health clinic and unfortunately killed a healthcare worker and seriously injured 3 others. That is why a huge coalition of healthcare workers, including the American College of Emergency Physicians, National Nurses United, the American Nurses Association, Association of EMTs, and many, many more have come together begging Congress to save their health and lives and enact this bill. No more delays. It's time for Congress to make this a priority and set some deadlines so that we can get the type of preventive measures in place nationwide that we know will save lives and livelihoods. Mr. Chairman, I'd like to ask that letters exchanged between Chairman Pallone of the Energy and Commerce Committee and Chairman Scott be submitted for the record. And with that, I yield back.
Without objection. Thank you very much. I want to thank everybody for their testimony. You have all been clear. I appreciate that. I don't really have any questions. I'd like to ask unanimous consent to insert in the record the Statement of Administration Policy on HR 1195 and HR 7, obviously in support of the legislation. And before I yield to Mr. Cole, I want to thank Chairman Scott for bringing these bills to the Rules Committee under regular order. We appreciate that. And with that, I yield to Mr. Cole.
Thank you very much, Mr. Chairman. Before I go to my questions, which are on HR 7, I just feel compelled to warn my very good friend, Chairman Scott from Virginia, that while Chairwoman DeLauro would never retaliate against you for misidentifying her state, the rest of the Appropriations Committee might. Please remember that in the future. We take the honor of our chairman very, very seriously on appropriations and hold her in high regard. So you allowed one mistake, but you're going to have some spending requests down the line. Just don't make another one. Let me turn now to HR 7 a little more seriously. Um, this is an important issue, no question about it. And I think we all agree that the idea of discrimination against anyone on the basis of gender is absolutely abhorrent and it's just unacceptable. The issue is not a partisan one. In 1944, actually, Republican Congresswoman Winifred Stanley actually introduced the precursor to the Equal Pay Act, which has been the law of the land now for, as you pointed out, Mr. Chairman, for 58 years. So doesn't the Equal Pay Act of 1963 already specifically make it illegal to pay different wages to employees on opposite sex for equal work? And if it does, then explain to me the need for additional legislation.
Well, thank you, and I want to thank the gentlelady from Connecticut for her hard work over the decades, and also wanted to put in a good word for HR 1195. It's just regrettable that we need to pass legislation to get OSHA to pass a regulation within 3.5 years, but that's pushing them and getting it done. So I want to state that. And also, Elsie Hastings, several have pointed out that he generally sat in the same seat on the floor. I didn't point out that most of the time I'm sitting right beside him. The point there is that we're sitting right beside staff people who are keeping track of the vote. And if you haven't voted, they can remind you to vote. A lot of times you get distracted and don't vote, and you can miss a vote. Happens all the time. But if you're sitting where Elsie and I usually sit, your staff will correct you. Will make sure that doesn't happen. So I'm certainly gonna miss them along with everyone else. The Equal Pay Act lays down the law. You can't discriminate on the basis of sex, but there's so many loopholes. And when you try to get into litigation, the problem is, as we've heard, if on account of sex, if you come up with some other reason that is not technically sex, but it is so correlated with sex that it might as well be. For example, prior income, prior wage history. If you've been discriminated against as a woman in your previous job and your new job, they can take your salary history and base your new salary on what your discriminated history is. You'll never get out of the box. You will always be behind the curve. And what this bill does, HR 7 does, the Paycheck Fairness Act, says if you're paying somebody, you have to have a legitimate business reason. If everybody's being paid on the same level and people who are historically discriminated against have been paid less, you have to have a business reason to continue to pay them less. It's just not fair. So that's one loophole that's closed. That if you're going to discriminate, you have to come up with a reason other than sex that has a legitimate business purpose to it, other than just perpetuating past discrimination. We equalize what the damages can be. In a racial discrimination case, you can get a lot more damages than you can in an Equal Pay Act case. This allows you to discuss your salary with others. If you most of the time you don't even know you were discriminated against. Lily Ledbetter never knew that she was making less than all the men. It was towards the end of her career that somebody whispered to her or slipped her the information that she found out that she was being paid substantially less than all the men and had been throughout her career. This bill provides that you can't sanction somebody for discussing pay. So there are a lot of things in here that facilitate the realization of the goals in the Equal Pay Act. And Rosa might want to say a little more about that too.
So, Mr. Chairman, and I thank the ranking member for the question. There's no doubt that the Equal Pay Act in 1963 made it illegal for employers to pay unequal wages to men and women who perform, and this was substantially equal work. What we're stating here is same job, same pay, men and women. But in what has persisted over the decades is that in the laws, and even though they have been, civil rights laws help change some of these efforts over the years to combat wage inequality, the laws have not closed a persistent gap between women and men's wages. And it is, and as I said, it's over $10,000 a year. And it is every single state, regardless of geography, occupation, education. You can look at broadcasters, museum directors, soccer players, engineers, university professors. There is a wage gap. And again, for Native American women, it is 60 cents. Black women, 63 cents. Asian Pacific Islander women are paid as little as 52 cents. So what the Paycheck Fairness Act does is close those gaps. It eliminates the loopholes in the Equal Pay Act. And that breaks the pattern of discrimination. So it's also important to note that when President Kennedy signed the Equal Pay Act into law, that was 51 years ago, this is what he said, and I quote, "It is a first step. It affirms our determination that when women enter the labor force, they will find equality in their pay envelopes." Now, but what the Equal Pay Act does, it brings the Equal Pay Act into line with the remedies that already are available for those who are subjected to employment discrimination based on race and national origin, as Chairman Scott pointed out. He also talked about, he mentioned Lilly Ledbetter. The person next to her was doing this very same job, and she was being paid less. She won in court, lost at the Supreme Court, never had 1 penny in recompense for her 24 years of work at the Goodyear Tire Company. This is happening all over the country, as I said, in every, it doesn't make any difference in what job you hold. And what this bill simply says is, if you and I are in the same job, we deserve the same pay. I bring up Congress again. People have different skill sets, different educational backgrounds, different histories of employment, and all of these areas, and yet we get the same amount of money. Why is that not true for every woman in this country? And it is about, if you can give the business reason and legitimate a business reason for doing this, then you have that's something that will be looked at. But what we have found year in and year out, that women suffer the economic consequences of pay discrimination. We have the opportunity to remedy it.
Thank you very much. Dr. Fox, let me turn to you, because in addition to the Equal Pay Act, obviously we also have Title VII of the Civil Rights Act that makes it illegal to discriminate on the basis of a variety of things: race, color, national origin, religion, certainly gender. It seems to me we have a legal framework already in place that addresses this. Do you agree with Chairman Scott, Chairwoman DeLaura, that the laws additional laws are necessary to address this problem?
I agree with you that we have a legal framework with robust remedies already under the Equal Pay Act and the Civil Rights Act. I do not agree that HR 7 is needed. In fact, as we both pointed out in our opening comments, HR 7 will reward trial lawyers for suing unsuspecting businesses without helping workers. HR 7 makes it much harder, if not impossible, for job creators to defend against frivolous lawsuits when a difference in pay is the result of legitimate factors other than sex. This change will stifle employers in recruiting and hiring all workers, including women. The bill also provides for unlimited compensatory and punitive damages, even while it expands class action lawsuits. And to add insult to injury, the bill requires the EEOC to collect mountains of employee pay data disaggregated by job category, race, national origin, and sex, in addition to hiring, termination, and promotion data. This draconian data collection mandate also raises significant privacy concerns for workers while having no utility in combating pay discrimination. What we're going to get is a mountain of data and no information. There's a heck of a difference between those. It's not going to protect the rights of workers as the bill sponsors claim. And I want to go back to comment on something that Representative DeLauro mentioned. She said that the 1963 law has not closed the persistence gap in pay. Well, that's not what the law was designed to do. It's not designed to do that. It's designed to guarantee there's no discrimination. It's up to the market to work out what happens with pay. And I just don't think this is going to help with that situation. It's not going to protect the rights of women as the sponsors claim it's going to do.
Well, let me be supremely practical here for a minute, Dr. Fox. To ask you another question. The Paycheck Fairness Act actually passed in 2008 and 2009.
2009.
Okay, and obviously did not get through the Senate. Cloture was never achieved, and there was a very substantial Democratic majority then, quite frankly, much bigger than the majority today. So I'm not sure this bill is going to have much of a chance in the Senate as it stands today. So I'm going to ask you, we all acknowledge we want to make sure that there's no discrimination based on gender. Are there some bipartisan things that you think would have a better opportunity of actually making it through both chambers and becoming law?
Absolutely. I think that Republicans have offered an excellent alternative that would garner bipartisan support. Representative Stefanik offered a substitute amendment at the committee markup, and to this committee that is modeled on laws in Massachusetts, the chairman's state, and New York, Mr. Morelli's state, which no one would consider to be red states. Like the laws in those states, this amendment encourages employers to identify potentially unlawful pay differentials and take steps to rectify any unlawful pay differentials. In addition, the amendment strengthens and clarifies the Equal Pay Act by ensuring that pay differences between employees of the opposite sex must be business related. I encourage my colleagues on the other side of the aisle to take up Representative Stefanik's amendment as the basis for moving a bipartisan pay equity discussion forward.
Thank you very much. Thank you, Mr. Chairman. With that, I yield back.
Thank you very much. Ms. Torres.
Thank you, Mr. Chairman. I too want to express my sincere condolences to the family of our colleague, Mr. Hastings. He was such an amazing human being who was a strong advocate for equality, human rights, and so passionate about equal justice under the law. And I will miss him dearly. Chairwoman DeLauro and Chairman Bobby Scott, thank you for coming before the Rules Committee today to present two very important pieces of legislation that are so critically important to working women, American working women. For too long, women have been fighting for equal pay for equal work. It's been over half a century ago that President John F. Kennedy signed the Equal Pay Act into law. It's time to take the next step. It is time to stop encouraging employers to do the right thing by their female employees. And it is time to utilize our laws to ensure that it happens. Yet here we are today, women are still paid much less than their male counterparts for equal work in many of our nation's companies. So I too, one of my very first jobs was in a male-dominated industry. You know, what happens is the employer ultimately loses a good employee as a result. And some of them will never know those reasons why their employees have left because they simply don't care. But you know, unfortunately, my story is not unique, as many women across the US have to deal with the same issues. If you do the work, everyone deserves to get the same pay. And your gender should not matter. It's about equality, and that's why I support HR 7, the Paycheck Fairness Act, which will take several steps to ensuring women get paid equally. Another bill that we have before us today would also help our workers. During this pandemic, we've seen healthcare workers put their own lives on the line to save others. These workers deserve our respect and recognition. And when it comes to violence in the workplace, they also deserve support and protection. Healthcare and social services workers experience 3/4 of all workplace violence, and that happens across the country. And there are reports that this violence has increased through the pandemic. So once again, I just want to thank the chairwoman and the chairman for coming to our committee and encourage my colleagues to support both of these bills. Thank you, Mr. Chairman. I yield back.
Thank you very much. I don't see Dr. Burgess, so I'm going to go to Mr. Rushenthaler.
Thank you, Mr. Chairman. I appreciate it. Ranking Member Fox, I just have a few questions regarding HR 1195. In regard to this bill, it's my understanding that OSHA is already in the process of rulemaking on workplace violence prevention in the healthcare industry. Why did the committee choose to circumvent the standard rulemaking procedures under the Administrative Procedure Act?
Well, our colleagues are saying that it takes too long to go through the regulatory process and come up with rules. But the reason that's done is to give stakeholders an opportunity to explain to regulators who may not have any experience at all in the industry what needs to be done and what can be done to protect workers. You know, we've seen that this entire session of Congress, people get in a rush to do things. And there's an old saying, haste makes waste, or act in haste. There's another one, act in haste and repent at leisure. It's much better for us to go through this methodically. All of us want to protect all workers. That's not an argument. We want to, it's not a partisan issue. We should do it right and not do it in a hurry. And issuing temporary rules without having gone through the regular order in rulemaking, just as we need to go through regular order for legislation, you'll wind up with something that isn't workable. So it's not necessary to do that. It's been working very well. OSHA's been doing what it should do under existing rules. And we're not hearing from industry that this is a big issue. What we're hearing is from our colleagues who want this top down, they want control in Washington, ultimate control here for everything.
Thanks, Ranking Member Fox. And in your testimony earlier, you mentioned the CBO estimate of just last year's version of this bill would have cost the private sector at least 1.8 billion, and that's billion with a B, and that's 1.8 billion in just the first 2 years. In your opinion, would there be any effects on healthcare costs for patients? And if so, to what extent do you see healthcare costs for patients rising?
Well, when you pass along higher costs, somebody's going to pay for that. And so it's ultimately going to go to the patients, or it's going to go to their families who are paying for them. And for very, very questionable things to be done. Look, our colleagues on the other side of the aisle seem to think that employers don't care about their employees. I believe that they do. They generally invest a lot of money in their employees, but they also are caring people, and particularly people in the healthcare and social services areas are very caring people. This is a tough business to be in. It's fraught with problems every minute of every day. And the people I've met in these industries care a great deal. And for the most part, the employees they hire care for the people that they're caring for carefully. And they have great heart for them. And we don't need to increase the cost. That might lower the ratios. That might lower the level of education for people that they hire. There might be all kinds of ramifications for this, and we simply don't need to add to their cost. We need to make their jobs easier. We've got an aging population in this country, and the last thing in the world we need is to slow down the opportunities for people to create places for elderly people to go and be taken care of compassionately.
Thank you, Ranking Member Fox. I appreciate it. With that, I yield back. Thank you, Mr. Chairman.
Thank you,
very
Mr. Reschenthal.
Thank you. Mr. Perlmutter.
Thanks, Mr. Chair, and just for Alfie, clearly one of my best friends. I always felt like I had a big brother when I was around Alcee. He always encouraged me. I liked, Bobby, you talked about it, the place that you guys sit on the floor, and when you weren't there, I would sit next to him. And I always felt I was in a safe place. In this business, sometimes you doubt yourself every now and again, and he would always encourage me and correct me if he thought I was wrong, but always encourage me. And he was one of the best lawyers I've ever met. I've got Jamie, I've got Mary Gay, I got lots of good lawyers around, but he was outstanding. And I know today he would be on a tirade because the complaint by the Republicans is, oh, we don't want to see discrimination. We want everybody treated fairly. We want that, but we don't want lawyers to make any money. That's the whole complaint today as to HR 7. And as Ms. DeLauro said, with Lilly Ledbetter, case went clear to the Supreme Court. She wasn't paid the same for 24 years and ended up with no compensation. And my guess is her lawyers did not as well. They take risk in righting the wrongs of people who have been harmed in the system. Lawyers get these things so that the issue is in front of a jury of their peers, and they stop businesses that want to make a profit, whether it's from their equipment or their people or their product, but businesses in this instance take advantage of the most vulnerable, the most susceptible to harm and abuse. And they do it ordinarily on a contingency to go right it. But when they win, they're entitled to be paid. And so I don't know if Ms. DeLauro wants to talk about that, but that seems to be the major complaint of the Republicans, and then I'd like to turn to my friend, Mr. Courtney. Nothing? Okay.
Mr.
Well,
Perlmutter?
I would say to Mr. Courtney, and I would respond to Ms. Fox. I have actually been approached unsolicited by emergency room docs and nurses that they support Mr. Courtney's bill because of situations where they've been attacked or threatened or the like by patients and by others, and feel that the bill is absolutely necessary. So, Mr. Courtney, I'd like to ask you, I mean, how long has this been going on? I know I've received comments and support from nurses and doctors for at least the last couple, 3 years. How long has this OSHA process been taking, and how much is it costing?
Sure. So real quick, so back in 2013, the Education and Labor Committee requested a GAO study, which again came out in 2016. Again, documented just again the overwhelming statistics that we've already heard mentioned here today, and again the trajectory of the injuries in terms of where it's going is it's increasing. And let's face it, you know, we all know what's going on. It's behavioral health and the opioid addiction crisis, that it's just creating all of these sort of, that's what's really the driving factor in terms of why it's going up so steeply in the present time that we're in. And by the way, that's continued during COVID as well. And those are flashpoints in terms of, you know, just, you know, patients and families and clients who are just completely out of control. And again, the system really just, it's been very sporadic in terms of setting up safeguards and protections when they, in many instances, clearly know there's high-risk patients involved. So in 2016, after GAO came back with a report, the Obama administration began the process of starting an OSHA rulemaking. It was towards the end of 2016. The Trump administration came into office. They terminated that initial scheduling of a small business review, and then basically brought it back up for schedule in 2018. They scheduled a hearing of the SBREFRA panel, that's the small business review panel, for January 2019. Then they delayed the January 2019 hearing until March 2019. Then they delayed the March 29th hearing until October 19th. Then they delayed the October 19th hearing until January 20th. Then they delayed the January 20th hearing until December 2020. And guess what? The clock ran out. And it's not like the administration wasn't, you know, doing rulemaking, you know, between 2019 and 2020. But the sad thing is that OSHA is notorious for how slow it takes to advance rules. So just looking at some of the recent standards which were adopted by OSHA after going through the regular rulemaking process. So they put an OSHA standard in for beryllium, which is like poison for workers. It took 18 years for OSHA to go through the rulemaking process for beryllium. Crystalline silica, the stuff when they cut granite for countertops and kitchens, that took 19 years for them to come up with a rule. Confined spaces in construction, you're a former laborer. You know, guys who are in trenches with the, you know, protections there, took 22 years to come up with a rule for confined spaces. Again, that was in 2015. Silica was in 2016. Beryllium was 2017. And we actually had a Republican witness testify before the Education and Labor Committee on this bill, who he said, yeah, OSHA is terrible. I mean, employers want OSHA to move faster in some instances because technology changes where sometimes, you know, it's favorable to employers to have, you know, rulemaking go on a faster basis. This bill sets up a 3.5-year process after enactment. Again, and this is not like we're starting with a clean sheet of paper. OSHA has had guidelines on the books for 25 years. The problem is that it's just too you know, ad hoc in terms of how those are actually used. It's completely voluntary. The cost estimates, which was discussed by Ms. Fox. Okay, let's think about this. 1.8 billion per year for the first 2 years, and then it goes down to about roughly 700,000 per year. That's over 200,000 healthcare facilities all across America. So if you do the math, we're talking about $9,000 per facility per year. I mean, you know, I had a hip replacement 3 years ago. The bill for that was $30,000, you know, at a hospital there. I mean, the notion that this is somehow going to, you know, have some major cost driver in terms of healthcare costs when we're talking $9,000 per facility. Again, it does not affect doctors' offices or small clinics or dentists' offices. We exempted them in this bill. So the small guys have nothing to fear or, you know, imagine feared in this bill. And those costs are definitely manageable. As I showed, you know, the reduction in workers' compensation costs that these standards can generate, the reduction in absenteeism that will, there will be huge savings for employers. And many of them have already either partially or totally already adopted it. So this is not, you know, we're not starting with some major new unheard of, you know, proposal. We have, you know, tried and tested techniques in terms of reducing violence, and it's going to make our healthcare workforce safer. 33 organizations, I didn't read them all, have endorsed this bill. Again, starting with the emergency room docs, all the way to nurses' aides groups. You know, it is, you know, really, it is unbelievable, as you said, Ed, in terms of how people will come up unprompted and unsolicited to talk about how concerned they are about, you know, they went into this profession because they care about people. They didn't get into it, you know, to basically, you know, engage in martial arts.
Mr. Perlmutter, can I respond to your
Yeah.
thank you, and thank you, Mr. Chairman. You know, the very same issue was brought up about litigation with regard to the Lilly Ledbetter Fair Pay Act. And you know what? There wasn't a mountain of litigation. There wasn't a flood of litigation, and what they had large punitive and compensatory damages, et cetera. It just did not happen. This is a consistent refrain from some of my colleagues, and it has to do whether it's minimum wage or whether it has protection of the workforce, that we are going to create, you know, a flood of litigation. And it hasn't been the case. And as been said, you know, equal pay for equal work is the law of the land, but it has weak provisions in it. And employers should already be complying. What the Paycheck Fairness Act does is makes the law clearer to both employers, employees, new tools for employees, and only if litigation is necessary. And we follow, in the Paycheck Fairness Act, follow very well-established principles that exist in other civil rights statutes that are known and followed by employers. We also know that the Equal Pay Act provides woefully inadequate remedies, back pay, and equal amount as liquidated damages in certain cases. So even if your case is successful today, the damages are often insubstantial. Women get little compensation, and employees with little deterrent from practicing future wage discrimination. And let me also make a point that what President Kennedy said in 1963 was this was a first step. And this is what that bill said in 63. It affirms our determination that when women enter the labor force, they will find equality in their pay envelope. That is what is not related. It's a concept from the Title VII, and it is familiar to both employers and to the courts. And I would just say to you, if education, training, or experience, if they are job related, they can be reasons to pay someone more than someone else doing the same job. Congresswoman Fox talked about, and so did Congressman Cole, about a Republican substitute. Well, it is really pretty extraordinary that we would take a look at something that relies on self-audit by an employer. to make that determination of whether or not they are discriminating against a worker. It is the fox in the hen house, if you will, here, and making that determination, and puts the victim of discrimination at a disadvantage, which is very similar to some of these other. There is unintended consequences with safe harbor bills, and the incentives should not come at the expense of an individual worker who may be suffering real harm. This is to women every year working full-time year-round. The wage gap represents the loss of more than $400,000 over the cost of her career. It impacts women's ability to save for retirement, reduces Social Security and pension benefits, and contributes to more older women living in poverty. Let's think about the women of the Congress. Should we change the rule in the Congress?
No.
That women who serve in this body, in the same job, get the same pay? I doubt if any one of my colleagues would like to see something like that enshrined, except what we have today, which is we are paid equally for the job that we do equally with the men who serve in this body.
Thank you. And I unleashed the passion of the both sponsors. And I thank you. I am a co-sponsor of both bills because I think they are so important. And I thank my colleagues from Connecticut. And just so you know, we would be honored if either or both of you chose to move to Colorado.
Right. Thank you. Ms. Fishbach.
Thank you, Mr. Chair. Just very quickly, in reference to HR 7, we're hearing a lot about the gender-based pay disparities, and we're hearing about all the regulations and actions that are going to be taken against those bad actors. But I'm just wondering, and maybe Ranking Member Fox, if you could just enlighten us on this, are there any safeguards in this bill for employers that are currently proactively and in good faith acting to address the gender-based disparities from legal and financial liabilities under this act?
No.
Okay, well, I appreciate brevity, so you answered the question. Thank you so
Thank
much.
you.
And that is my concern, as you take a look at this, because there's so many regulations and things that could happen to someone that is they're just thinking that there's a gender-based pay disparity, and so I'm concerned that there's no kinds of safeguards for those that are good actors that are doing what they need to do and proactively. But if you have any other comments,
let me add one comment. I think it will be important, and I think we'll be able to put into the record some material to show that this gross difference that keeps being talked about in pay is indeed not what it's represented. Because when you control for experience, education, special talents, those kinds of things, there is just not that widespread gap in pay. I want to say, I've worked since I was 10 years old. I've worked all my life, and I've worked predominantly in male professions too, or where males predominate. There is nobody in this body who wants to see a woman discriminated against in any way. I've fought all my life for equal rights for women and equal treatment for women. And if I thought this bill would help women, I'd be there. But this is not going to help them. What's going to help them is to be guided into the professions that pay more, and and our culture should be respecting the jobs that women are in to begin with, Why is it that elementary school teachers are paid so poorly and college teachers are paid so well?
They're not.
You know, I've advocated for a long time that we reverse that. College professors where I used to work, we believe they have the cream of the crop, so to speak, and yet they're paid a lot more. Why is that? Number one, it's because it's predominantly always been a male profession. And our culture has for a long time honored those people more. I think it's backwards. And I worked in those kinds of jobs. It's the elementary and secondary teachers who have the toughest job. So I think our whole culture has discriminated against women for a long, long time because we have not respected the nurturing jobs that they do. So, but that's something we have to deal with as a culture. It won't change because trial lawyers bring lawsuits.
Would
Thank
general, would the
Thank
gentle
you.
lady
Thank you.
yield for a moment? Would the gentle lady
Yeah.
yield? If you go to the American
Certainly,
Association.
briefly, I'll yield.
Oh, fine, but I will just say to you that in response to your first question, I said very, very clearly, and it's right in the legislation, if the employer has an affirmative defense of a, quote, factor other than sex, the Paycheck Fairness Act, and they can say that the differential is business related or necessity. This is very familiar in Title VII, which is the law on the books, and that the employers know about this, the courts know about this. So if it's education, if it's training or experience, they are job related. They can be reasons to pay someone more than someone else doing the same job. So yes, they are protected in this area. I would say to Congresswoman Fox that you go to the American Association of University Women, and they will tell you at their elevated professorial profession that they are discriminated against. They are in the same job as a male professor in the same department. They are not paid the same amount of money. That is what is at stake here. Again, you ask any woman in this body if we should revert to the system that every other woman in this country has to face. Should we? Probably not. Thank you. Thank you. Thank you. I can't yield back, but I thank you for the time.
And I would just like to, in reference to HR 1195, I'd ask, wondering if Representative Courtney would just kind of talk about, if we, my understanding of this bill is that we're expediting normal rulemaking process, and but if we waive that normal rulemaking process, what opportunities do American businesses, the people that will be affected by this, have to comment on the regulations before it goes into effect?
Well, thank you for asking that, because the fact is that this does not waive any kind of hearing process or input process from both sides in terms of the development of a rule. And that's true of the interim standard, by the way. The interim standard, which is just a program standard to sort of begin the process of planning for different facilities in terms of what are best practices for training and identifying risk, which again is not the same in every facility. And I'm the first to acknowledge that. I mean, if you got a psychiatric hospital, that deals with really troubled and disturbed patients, it's a much different level of prevention that is than a facility that deals with primary care or and again, we exempted the small guys. Want to make that clear. I can give you citations of the text if you want to get into that. But the fact is the process is still in place for input in both the interim standard and the eventual standard. It's 3.5 years from enactment. And like I said, we're not beginning from scratch. The guidelines that OSHA has put together, which groups like the American Hospital Association, which are uncomfortable with this bill, I know that, I've talked to them. you know, they know this. I mean, they understand what OSHA's already put together, and they endorse it. I mean, they compliment it in terms of, you know, because it's well thought out stuff, but they're not going to be, you know, deprived of an opportunity to come in and tweak. And we put in language that made it clear that it is to be tailored for the specific facility in terms of the risk level that they encounter with patients. And again, my wife's a a nurse practitioner. You know, you know, you know, I'm surrounded by this, and many of us, you know, either in healthcare or you know, in families, they know it's just not the same in every type of facility. And we wrote the bill to reflect that reality.
And thank you. And so there isn't going to be a shortened or abbreviated time period for businesses and individuals to have input. Is that correct?
So the interim standard, which again allows for input, you know, I mean, it's going to be faster than the 18 years, 19 years, 22-year process, but you know, there's going to be an opportunity. And as I said, that piece, I don't think people should get that hung up on, because it's really just sort of trying to get the development process started. The 3.5-year window, I think it's just plenty of time in terms of developing the final standard, given how far along the process is already. And again, I just want to emphasize that there's precedent for this. You know, OSHA is an act of Congress, and Congress has stepped in the past in situations to accelerate the rulemaking process. They did it when the AIDS pandemic took place back in the 80s and early 90s. Again, they worked with the Bush administration to develop the bloodborne pathogen workplace standards that, you know, that's why everybody wears the gloves and they have the disposable needles. That's all OSHA, you know, that was developed. And again, it was done with congressional sort of intervention, because obviously they realized that the risk for people, you know, who were, whether it was first responders, who needed, you know, protection from exposure to blood, or people in hospital settings, that they needed to move that along. So we've done this before. This is not unprecedented.
Well, and Representative Courtney, I guess I just have to ask again, does the bill abbreviate or shorten that? I guess I'm not, maybe I'm still not.
No, the answer is no. I mean, so the
Okay,
first step,
all right.
yeah, sorry.
No, that's okay.
No,
Well, and I thank you for the information. I just wanted to confirm that it had not been shortened, but
yeah, but those,
and Mr. Chair, I yield back my time.
Thank you very much. So I think one of the witnesses I know is under a time crunch, so I would, if we could maybe just keep that in mind, because I think we want to make sure everyone gets to ask questions here. Mr. Raskin.
Thank you, Mr. Chairman. I will not take that admonition personally.
It wasn't meant for you, because you're always to the point. Yeah, everybody's to the point. It's not meant at anybody. All right.
Let me just add one word in praise of our late beloved and lamented Mr. Hastings. Alcee is someone we will all sharply miss, and I will very much miss his great sense of history and perspective that he brought to everything that we were debating. And I remember him once saying to me during a particularly contentious debate, you know, if people studied more history, they wouldn't be so fanatical about the things that they're saying now. And that really stuck with me. I mean, he was about the least fanatical person you could ever meet. He had a great sense of being oriented in place and time, and we'll think about him a lot, and we send love, of course, to his family. I just had a couple of points about where we are, Mr. Chairman, and sometimes I think that conservatism is the art of saying that the laws that we have now, which they strongly oppose passing in the first place, are doing a great job, and it's unnecessary to improve or update them in any way. You know, it's the argument that I've heard most here is, well, we don't really, you know, need to have the Paycheck Fairness Act, because the law that we have now, which forbids explicit gender discrimination, is quite is quite enough. But of course, when those laws were passed, it was said, let the market take care of it. If if it's actually bad for businesses to discriminate, they won't do it. But we understood that discrimination against women has been deeply rooted in culture and in society, and we passed those laws. Those laws are not enough now because no employer is foolish enough to come out and say, well, we're going to pay women 60% of what we're paying men. They understand that will get them a lawsuit, but they can just go ahead and do it and try to maintain that it has to do with some other kind of natural difference or just some sort of contingent event that has nothing to do with gender discrimination. And I think that women in America, men in America, the society is just too smart for that. And I think that the Paycheck Fairness Act is totally warranted today. And I was just wondering, one question for Ms. DeLauro and then one for Mr. Courtney. Ms. DeLauro, do you believe that the market will just take care of this if we just say, as long as nobody explicitly discriminates, everything's okay?
Well, let me thank you. I thank you, gentlemen. Thank you for the question. I have in front of me employment and earnings by occupation. Okay, and this is with regard to what the market is. I can go through this. It's an alphabetical listing. We talk about civil engineers. Men make $91,000 a year. Women $79,000. Same jobs. Child care workers, $25,000 for men, $22,000 for women. Whatever profession you are looking at, detectives, criminal investigators, $90,000 for men, $71,000 for women. Economists, $122,000 for men, $102,000 for women. If we have to rely on the market, I'll be very upfront with you, and without any intervention here. In a book I wrote several years ago called Waging the Battle for the Vulnerable, I said if we did not intervene in some of these areas and make bring government into the to bring equity into a number of these areas with regard to safeguards for men, for women, for children, etc. And if we didn't do that at the government level, then excuse me for this, then we are all screwed, because it is all about really allowing, when we see what the discrepancies are and where the discrimination lies, that we in fact have an obligation to correct that. And that is exactly what the Paycheck Fairness Bill does, because the market is not protecting that, and it hasn't done that substantially.
Madam Chair, thank you very much for that lucid explanation. And Mr. Courtney, but I was very taken with Mr. Perlmutter's point about the attack on lawyers, which seems to be an irrelevant distraction from whether or not people are going to have rights to gender equity. And I'm just wondering why you think this ideological attack on lawyers or trial lawyers comes about in certain circumstances, but not in others. I mean, as you know, I spent a lot of my time this year on the impeachment trial of President Trump, former President Trump, for inciting a violent insurrection against Congress. He had brought 62 lawsuits. He had teams of hundreds of lawyers suing every state that he thought was getting in the way of what he still maintains as his victory in the presidential election. He sued lots of counties. He had tons of trial lawyers. He spent tens of millions of dollars that he raised from supporters to do it. And nobody said, oh, well, we should stop him from exercising his rights to due process because some trial lawyers are getting rich. That's how our system works. I mean, if you want to abolish the civil justice system and go to a king, I suppose you could get rid of all the trial lawyers. I just looked up a website. There's a website that has all of Donald Trump's litigation, more than 3,500 lawsuits. And the vast majority of them, he's the plaintiff. He's the one who's bringing the lawsuit. There are a lot where he's a defendant. He's being sued by small businesses, small contractors, painters, plumbers, engineers who he hasn't paid on different projects. But well, what do you think about attacking civil rights laws on the basis that you need trial lawyers to enforce people's rights?
So, well, thank you for asking that question. Again, my Republican father, who practiced law for almost 50 years, was somebody who used to get very irritated sometimes when he heard that kind of rhetoric, which has been around for a while, talking about Elsie's historical perspective. I mean, it's been a commonplace complaint. Even Abe Lincoln, used to talk about, that sort of argument that he heard a lot of, back in the day. And, all I would say is, again, I have a brother who was actually in a litigator who in the area of employment law. And I will just tell you this, there is no almost less lucrative, area of law. An area, and even with, Rose's bill being enacted, it's still going to be, the notion that the floodgates are going to open and it's just going to be, this opportunity for, people to, that's just really not what that area of the law looks like, in terms of, creating some, bonanza that's out there. So again, I feel like, just in terms of the reality of what we're talking about here, it is so overhyped.
I got to say, the people I went to law school with, the ones who went into corporate law and mergers and acquisitions, those people are multimillionaires and have fancy houses. The people who went into civil rights law or criminal defense, most of them are, still living in the apartments that they were in when we were in law school, so which isn't to say that some don't make money, and compared to people who aren't lawyers do make more money than school teachers, for example. But I think your point is right. And it is really a distraction from the rights that we're talking about, the rights of women, our daughters, our sisters, our wives, our mothers, to earn what they deserve to earn, the same as men in the same fields. Thank you very much, Mr. Corley. Mr. Chair, I yield back to you.
Mr. Raskin, can I respond to one of the questions?
Please, Mr. Chairman.
Yeah, you mentioned the marketplace. One sinister example of what you're talking about that we correct is the use of salary history. Because if you let the market prevail, you come in with the market history based on discriminatory practices, and you get your salary set at that level where someone else is not subject to discrimination gets a higher salary. All you'll do is perpetuate let the market perpetuate salary discrepancies. And that's what we try to correct in that, and try to disturb the market by saying, no, the market can't use that normal example of setting salary. You can't use salary history, because all that will do is perpetuate past discrimination. We're going to try to get people hired force you to look at what are you hiring, what are you paying for this job, and men or women, that's what you pay, not based on whether or not they've been discriminated, have a history of discrimination coming, and try to get away with a lower pay. And if that keeps going, the market will consistently pay women lower.
Yeah.
That's what we're trying to fix.
Well, thank you, Mr. Chairman. We want a market that's structured by law and by justice. Mr. Chairman, I yield back to you.
Thank you. I just noticed that Dr. Burgess is here. I don't know if you have anything you want to add or before.
Yeah, thank you, Mr. Chairman. I think I'm going to get ample opportunity to talk about this tomorrow, so I'll defer. But I would also point out I'm sitting adjacent to the Elsie Hastings chair, and while I feel his absence, I also feel his presence, and we will miss him. But I'll yield back to you, Mr. Chairman.
Thank you very much. Thank you. Ms. Scanlon.
Thank you, Mr. Chairman. And I too miss our colleague, Elsie Hastings. I really enjoyed our conversations about our shared passion for civics education. And he was a great proponent of civics education. It's something that appears to be more important now than ever. So we will dearly miss him. With respect to the Paycheck Fairness Act, we've discussed the gender wage gap, where women in this country earn about 82 cents on a dollar that men earn. But it's important to realize that that wage gap is compounded year over year, resulting in a wealth gap where women in this country only have about 32 cents on the dollar for wealth that men in this country do. So it's really important that we figure out how to redress that balance. We've heard today that the Equal Pay Act and other statutes are supposed to have provided the framework to redress this illegal conduct, this inequity. But 58 years in, it's clear that it hasn't done so. So we need to adjust that frame. And that's exactly what the Paycheck Fairness Act tries to do. It's a rational next step. And I'd like to focus particularly on one aspect of the Paycheck Fairness Act, and that is the fact that it adjusts the burden of proof. So an employer under this act would need to show that they are paying employees fairly, not based on gender. That's the only fair thing to do because the employer has all the information. It's also not a wild-eyed radical view because in fact other countries do the same thing. Iceland in 2018 passed a bill that shifted this burden of proof, and they've gotten great results from it, increasing equity in their payment system. So I do think this is a necessary adjustment to our framework in order to address the reality of the fact that the marketplace has not addressed the issue of pay inequity. Chairwoman DeLauro, has the pandemic increased the urgency to get this bill passed?
Yeah, I believe it does. Thank you for the question, and I appreciate it, and I thank your comments on the the market aspect of all of this. I think I said at the outset of my comments, I think that the pandemic has exacerbated what we've known to be the inequities of the past, and the economic inequities that really deal with the economic insecurity of women and their families. This has existed for quite some time, and I think that the virus has in fact exacerbated that and have put women at a just in an untenable position. We have now today over 5 million women have lost their jobs. They are not opting out of the workforce. They are being pushed out of the workforce. One of the prime reasons for that is another issue, which is childcare and the lack of childcare and the lack of childcare of a childcare industry, if you will, that is going under. And that's why both the issue of the rescue package, which deals with the $40 billion for the child care industry. And my hopes is that we will build on that in the American Families Act, where you have a child tax credit, which helps lift, it's a lifeline for the middle class, and it lifts 1/2 of children and their families out of poverty. We need to look at these. I mean, I think these all fit together. It's not one or the other. And you look at paid family and medical leave. These are economic necessities for women today, but for women and their families today in order to be able to succeed. So I think that we do have the opportunity now. And I think about the Paycheck Fairness Act. I introduced it in 1997. So, and we passed it 3 times in the House in a bipartisan way. My hope is that, like I experienced with the child tax credit, that after 18 years of promoting that effort, that we are at a time and a place where the virus has focused us in on the inequities, and that will help us to turn the corner. And that's what my hope is here in terms of the Paycheck Fairness Act. It really is time, and it's a new age, it's a new environment. Women are in a different position than they were in 1997, and all those pieces, I think, move us forward to being able to pass this legislation in the House and the Senate, is my hope, and get signed by the president.
Thank you for your advocacy on this. It's much needed. I just wanted to comment on the red herring about this being a boondoggle for trial lawyers. I mean, it overlooks, as Representative Raskin mentioned, that's not how this works. Trial lawyers don't recover unless they're able to prove that there's discrimination. So it's kind of putting the rabbit in the hat. The trial lawyers won't make any money off this unless in fact there's discrimination out there to be proven. So I guess that means there is discrimination. I do have to disagree with Representative Raskin's attempt to make a parallel with the former president's lawsuits, because if the prerequisite to getting paid in those lawsuits is that they had to win, then they didn't get paid. And based on the former president's history, I hope they got retained in advance. With respect to HR 112595, the workplace violence against healthcare and social workers, as Representative Courtney described, this has been a top of mind issue in my district, where healthcare is one of the major industries. He mentioned the fact that Thomas Jefferson University Hospital has been trying to work on this issue. You know, like Representative Courtney, we've seen, I've had multiple groups come to me, including a physicians group just yesterday, saying, please sponsor this bill. It's a rising issue. 4 or 5 years ago, we had a shooting in a local hospital where a social worker was killed and a doctor was shot. This has been a growing issue. It is way past time for us to take action. So looking forward to passage of this timely bill as well. And with that, I would yield back.
Mr. Morelli.
Thank you, Mr. Chairman, for having this meeting today on these two very, very important pieces of legislation. I want to echo the comments of my colleagues about our colleague and friend, Mr. Hastings. I think it says a great deal about LC that those of us, particularly who served with him on the Rules Committee for long hours, and this is only my 3rd year on the committee, but we spent a lot of time together. But it says so much that every single person has so much to say about his generosity of spirit, his kindness, his warmth. I spent much time on the floor. We would talk about how he was feeling and what he was going through, and he just imparted such wisdom and was such a gentleman. And I spoke with him a few weeks ago. I called him, and he had just gotten home from the hospital. It was weak, but you could still hear that warmth and that generosity and that passion come through the telephone. So we will miss him dearly, and I appreciate very much his kindness to me and the opportunity to have served with him. On the matters before the committee, I want to, first of all, thank my distinguished colleagues from the state of Connecticut, Mr. Lauro and Mr. Courtney, for these bills. I had the chance to participate in the debate on them in the Education and Labor Committee. I want to thank Chairman Scott for his leadership on so many of these important issues. As it relates to the Paycheck Fairness Act, there's a
Mr. Morelli, Mr. Chairman, can I be excused? I think you referred to the fact that I had a meeting with the speaker at 3 o'clock that I have to run to.
Yeah, let me, is anybody object to that? No objections, you can be excused. Okay,
Good. Thank you. And I leave behind 2 distinguished members who can answer all the questions.
thank you.
Thank you. I'm sorry, John.
No, not at all. Thank you, Mr. Chairman. I started to say, in my home, there's a poster that hangs, and it's a picture and a quote from Clara Barton, who was obviously famous now for having created the American Red Cross. And it says, "I shall never do a man's work for less than a man's pay." On Christmas Day, we will celebrate her 200th birthday. 200 years, the 19th century, she said that. And she actually, at one point, was asked to teach and said she would do it for free rather than doing it for less pay than a man received, and ultimately fought for and received equal pay commensurate with her male colleagues. But I think it's extraordinary. 200 years later, we're still fighting the same issues. And yes, there have been and there has been legislation in the past to try to address this, but you just need to look at the data. You want to know whether that's been successful. The law of the 1960s and laws passed since then, just look at the data. It's pretty simple and it's pretty telling, and it withstands all kinds of scrutiny and all kinds of analysis. But it is crystal clear women still today in the 21st century do not make the same pay that their male colleagues do. And we have every responsibility to make amends for that, to address this. And I think the legislation advanced by my colleague and friend, Mr. Laurel, will do that. And I wanted to echo what my friend Mary Gay Scanlon said, which is, you want to avoid legal costs, don't violate the law, don't discriminate, pay people equally. And so when I walk past that poster when I get home, I'm going to think about that again. I think about this debate, and so grateful that Mr. Laurel is providing this leadership in the House. Hopefully we'll pass a rule today, and we'll pass this on the floor this week, and then look to our Senate colleagues to be able to make this significant movement, which is long overdue. As it relates to Mr. Courtney's bill, I was just thinking about, with all that's going on in the world, whether it's questions of police protection and public safety, or just the challenges brought about by the pandemic as it relates to isolation and suicide, that more and more social workers and mental health professionals are going to be called on to really intervene in sometimes very, very tense and sometimes very difficult situations. And they are more than needing of this protection. And so supporting them and making sure that we offer every protection to our mental health professionals, social workers, seems to me is far overdue. So I appreciate my colleagues' work on this, their leadership. I appreciated the opportunity to work on this in the Education and Labor Committee, and I look forward to not only supporting the rule, but also the bills on the floor. And with that, I yield back, Mr. Chairman.
Thank you very much, Mr. DeSaulnier.
Thank you, Mr. Chairman. I just want to join in your sentiments and all my other colleagues about Representative Hastings and how much I will miss him, how grateful I am to have been able to serve with him. What a lovely human being he was, and his teasing, his good sense of humor about how quickly I would be able to move around the table and be at his position next to the chairman, which I found quite charming and amusing. So I wanted to add those comments. Other than that, I look forward to voting for both of these bills and thank the authors from the great state of Connecticut.
Yeah, thank you very much. Ms. Ross.
Thank you, Mr. Chairman, and thank you to the bill sponsors for bringing these tremendously important and overdue issues to us. Particularly the Equal Pay Act, it's even more reason why we need the ERA, which we talked about last month. If we had the ERA, we would know that women would have the highest degree of protection, both under our Constitution and under our laws. But unfortunately, we're not there yet. So it's up to us to make sure that women get equal pay for equal work and received heightened scrutiny when they're discriminated against. I have not been working on this issue as long as our distinguished chair of the Appropriations Committee, but I have been working on it for a couple of decades. And when I was serving in the North Carolina General Assembly, I spearheaded efforts to pass a statewide Equal Pay Act and a study of state salaries. And both of those bills died in the Rules Committee. So I'm very happy to be on a Rules Committee that is taking this up. And then for the benefit of my colleague from North Carolina, who was a state senator, I want to share what the senator who chaired the Rules Committee in North Carolina, and she and I both know who that is, told me about my pay equity study. And he said, we wouldn't want to do that because we know exactly what we would find. And that has been what's been going on too long. I even got a smile from you, Congresswoman Fox, our dearly departed Senator Rand. But our nation's failure to recognize the immense contribution of women to our economy and ensure female employees are paid fairly for their contribution hurts women and it hurts families. The toll of gender-based wage discrimination cannot be understated, especially when it's increasingly common for women to be the sole breadwinners in their family. It's simply unconscionable for these families to be on the average 20% poorer than their counterparts with male breadwinners. Pay inequity follows women into retirement as well. Lower lifetime earnings lead to lower Social Security benefits and lower pensions. And many women are not even eligible for pensions because of the jobs that they have. Today, women have, on the average, only 70% of the retirement income men have, and they live longer. Paycheck fairness will begin to remedy these problems. In doing so, it will add over $500 billion of earnings into our economy. Paying women equally will have important ripple effects, including cutting the national poverty rate for working women in half and benefiting 25 million children. The bill also increases companies' ability to retain talent. In the tech industry, which has a huge presence in my district, in North Carolina's Research Triangle, women typically make thousands of dollars less than men in the same role. One report found that tech companies offer women 4 to 45% less in starting pay for the exact same job. Unsurprisingly, women in tech often leave the industry due to unfair compensation. This comes at a cost to the entire industry. The negotiation skills training grants provided through this legislation are crucial to ending gender-based wage discrimination and its effects. The bill will enable women to gain and employ key negotiation skills and advocate their worth, which is one of the many reasons I support this legislation. It also is something that's advocated in this wonderful book for anybody who wants to learn more about pay disparity, Ladies Get Paid. It just came out hot off the press, and the woman who runs around doing these trainings all over the country and all over the world should be commended. She formerly worked at Red Bull. For all of these reasons, and for the next generation, please, please support this bill. It is so sorely needed. As to the Workplace Violence Prevention for Healthcare and Social Services Workers Act, nurses, social workers, and psychiatric home health personnel care aides are all at increased risk of workplace violence. In 2018, healthcare workers accounted for 73% of non-fatal workplace injuries and illnesses due to violence. Healthcare workers in my state have experienced significant incidents of workplace violence. One nurse was choked by a patient with a stethoscope. Others have been struck, cut, bruised, and bloodied. In February, a VA medical center in Durham was locked down due to reports of an active shooter on the premises. Fortunately, no injuries resulted. In 2019, North Carolina's Governor Roy Cooper signed a law which makes assaulting a healthcare worker a Class D felony. While this law is an important step, our focus needs to be on prevention, and that's exactly what the bill before us does, especially in light of the COVID-19 pandemic, which has created new threats and challenges related to workplace violence. The fearless workers who put their safety and their lives on the line to care for others deserve protection from violence. And this Congress has a responsibility to care for those who care for us. Requiring the development of workplace violence prevention plans is a common sense solution that will reduce violence that healthcare and social services workers face all too often when they are doing such important work. This is a crucial bill. I firmly support it. Thank you, Mr. Chairman, and I yield back.
Thank you very much. Does any other member of the committee wish to ask a question? Seeing, hearing, and sensing none, I want to thank the panel, the witnesses for being here, and you are now excused.
Thank you, Mr. Chairman.
All right, thank you very much. Are there any other members that wish to testify on HR 7 or HR 1195? Seeing none, That closes the hearing on HR 7 and HR 1195. At this time, the chair will entertain a motion from the distinguished gentleman from California, Mr. DeSaulnier.
Thank you, Mr. Chairman. Mr. Chairman, I move the committee grant HR 7, the Paycheck Fairness Act, a structured rule. The rule provides 1 hour of general debate equally divided and controlled by the chair and ranking minority member of the Committee on Education and Labor. The rule waives all points of order against consideration of the bill. The rule provides that the amendment in the nature of a substitute recommended by the Committee on Education and Labor, now printed in the bill, modified by the amendment printed in Part A of the Rules Committee report, shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule provides that following debate, each further amendment printed in Part B of the Rules Committee report not earlier considered as part of amendments en bloc pursuant to Section 3 shall be considered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and the opponent, may be withdrawn by the proponent at any time before the question is put thereon, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule provides that at any time after debate, the chair of the Committee on Education and Labor or his designee may offer amendments en bloc consisting of further amendments printed in Part B of the Rules Committee report not earlier disposed of. Amendments en bloc shall be considered as read, shall be debatable for 20 minutes, equally divided and controlled by the chair and the ranking minority member of the Committee on Education and Labor or their designee. Shall not be subject to amendment and shall not be subject to a demand for division of the question. The rule provides 1 motion to recommit. The rule further provides for consideration of HR 1195, the Workplace Violence Prevention for Healthcare and Social Services Workers Act under a structured rule. The rule provides 1 hour of general debate equally divided and controlled by the chair and ranking minority member of the Committee on Education and Labor. The rule waives all points of order against consideration of the bill. The rule provides that the amendment in the nature of a substitute recommended by the Committee on Education and Labor now printed in the bill shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule provides that following debate, each further amendment printed in Part C of the Rules Committee report not earlier considered as part of amendments en bloc pursuant to Section 6 shall be considered only in the order printed in the report, may be offered only by amendment designated in the report, and shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and opponent, may be withdrawn by the proponent at any time before the question is put thereon, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule provides that at any time after debate, the chair of the Committee on Education and Labor or his designee may offer amendments en bloc consisting of further amendments printed in Part C of the Rules Committee report not earlier disposed of. Amendments en bloc shall be considered as read, shall be debatable for 20 minutes, equally divided and controlled by the chair and the ranking member of the Committee on Education and Labor or their designee, shall not be subject to amendment and shall not be subject to a demand for division of the question. The rule provides 1 motion to recommit. Finally, the rule waives all points of order against the amendments printed in Parts B and C of the Rules Committee report en bloc described in Sections 3 and 6 of the resolution.
You heard the motion from the gentleman from California. Is there any amendment or discussion? Mr. Cole?
Mr. Chairman,
Yes.
thank you very much. First of all, I just want to thank you for what we think is a very generous rule. You made most of, I think, all the amendments in order. And so I will only have 1 motion, and just to be Frank, it doesn't really deal with the
Sure.
legislation in question, where you, again, have been very fair and we're very appreciative. Mr. Chairman, as you're well aware, the House is finally beginning to return to some sense of normalcy as more members with access to the vaccine and staff continue to get vaccines. I was encouraged to hear from the Majority Leader Hoyer that we would begin to cut vote times down to 30 minutes. I think that's something we'll all welcome on both sides of the aisle. And just yesterday, the House reopened dining options, some which sold out within hours of reopening. The committees have continued to do their work with 50 committee hearings, 4 committee markups in the last committee work week. That's why I will again bring up the issue of allowing resolutions of inquiry to move forward. It just seems to me that, and many on our side, that this is a mechanism that the majority leadership is using to lock down the House and to avoid dealing with inconveniences. Mr. Chairman, I'd yield to you for a response, but what reason is there to neuter resolutions of inquiry other than to avoid, posing difficult questions to the administration?
Well, yeah, I hear the gentleman. As the gentleman also knows, unfortunately, we've had a lot of extra votes to deal with. And so we're trying to get to where you are, and I will certainly talk to our leadership, but understand I've been getting complaints from members on both sides of the aisle about the multiple votes, and in some cases unnecessary votes that we're casting. But I hear the gentleman. I'm going to oppose his amendment at this moment, but hopefully we can fix this.
Well, I accept that. I know that in good faith you're trying to do that. And, I have some sympathy with some extraneous activity. I think it would be less of it if we had more productive things to do. And I think this would help in that regard. But again, I understand my friend, the chairman's position on this. And I appreciate the fact that you are, I know, trying to continue to work with us. But just for the record, I'll go ahead and press the amendment, but it's the only one I'll be opposing today. So we can get through this pretty quickly, Mr. Chairman.
Okay. What's the motion?
The motion would be to strike various provisions of the rule and go ahead and add language to the resolution that would eliminate the tolling of days for the resolutions of inquiry.
All right, you heard the gentleman's amendment. Any discussion? Hearing none, the vote is on the Cole amendment. All those in favor say aye.
Aye.
Opposed, no. No. I think the noes have it.
Mr. Chairman, on that, I'd ask for a roll call.
A roll call vote has been requested. Clerk will call the roll.
Mrs. Torres.
No.
Mrs. Torres, no. Mr. Perlmutter.
No.
Mr. Perlmutter, no. Mr. Raskin.
No.
Mr. Raskin, no. Miss Scanlon.
No.
Miss Scanlon, no. Mr. Morelli.
Mr. Morelli is no.
Mr. Morelli, no. Mr. DeSaulnier.
No.
Mr. DeSaulnier, no. Miss Ross.
No.
Miss Ross, no. Mr. Cole.
Aye.
Mr. Cole, aye. Mr. Burgess.
Aye.
Mr. Burgess, aye. Mr. Reschenthaler.
Aye.
Mr. Reschenthaler, aye. Mrs. Fishbach.
Aye.
Mrs. Fishbach, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk, report the total.
4 yeas, 8 nays.
The amendment is not agreed to. Are there further amendments? Hearing none, then the vote is on the motion from the gentleman from California. All those in favor will say aye. Aye.
Aye.
Opposed, no. No.
No.
In opinion of the chair, the ayes have it.
Mr. Chairman, on that, we would request a roll call vote.
A roll call vote has been requested. Clerk will call the roll.
Mrs. Torres.
Aye.
Mrs. Torres, aye. Mr. Perlmutter.
Aye.
Mr. Perlmutter, aye. Mr. Raskin.
Aye.
Mr. Raskin, aye. Miss Scanlon.
Aye.
Miss Scanlon, aye. Mr. Morelli.
Mr. Morelli is aye.
Mr. Morelli, aye. Mr. DeSaulnier.
Aye.
Mr. DeSaulnier, aye. Miss Ross.
Aye.
Miss Ross, aye. Mr. Cole.
No.
Mr. Cole, no. Mr. Burgess.
No.
Mr. Burgess, no. Mr. Reschenthaler.
No.
Mr. Eschenbauer? No. Mrs. Fishbach?
No.
Mrs. Fishbach? No. Mr. Chairman?
Aye.
Mr. Chairman? Aye.
Clerk report the total.
8 yeas, 4 nays.
The motion is agreed to. And Mr. DeSagne of California will be carrying it for the majority.
Mr. Burgess will be carrying it for the Republicans, Mr. Chairman.
And I guess that's it for the week. So without objection, the Rules Committee is adjourned.